Good morning, everyone. It's great to see so many people here, and a special welcome to everyone who's watching online. My name's Andy Varco. I'm with Boyd & Gray and Associates here in D.C. I'm the chairman of the Executive Committee of the Federal Society's Environmental Law and Property Rights Practice Group. If you're interested in contributing to the work of our group, please let me know or talk to a Federal Society staff member. We have a fantastic panel this morning on a very timely and important set of legal and policy issues that are percolating even as we speak through the U.S. court system, including the U.S. Supreme Court. Guiding our discussion of these issues today is our distinguished moderator, the Honorable John K. Bush of the U.S. Court of Appeals for the Sixth Circuit, whose chambers are in Louisville. Judge Bush is an honors graduate of the Harvard Law School and of Vanderbilt University. Earlier in his career, he clerked for the Eighth Circuit and practiced law here in D.C. with Gibson, Dunn, and Crutcher for several years, and more recently, before his appointment to the bench last year, he practiced law in Louisville with Bingham Greenbaum Dahl, LLP, where he was co-chair of the firm's litigation department. Judge Bush will introduce the members of our panel, and please give him a very warm welcome.
Thank you, Andy. For this distinguished panel discussion today on climate change, I wore my green tie. Seriously, though, there are very important issues at stake in this litigation, the type of litigation that we're going to be talking about today. The recent lawsuits against companies in the fossil fuel industry and against the federal agencies seek to address what plaintiffs believe are devastating environmental consequences from fossil fuels' contribution to climate change. The private defendants face claims based on liability theories of public nuisance and public trust for many billions, if not trillions, of dollars in damages. And the government defendants defend against claims seeking a wide-ranging injunctive and declaratory relief that could transform the way they regulate and govern a substantial amount of the nation's economy. But I'm not an expert on any of this, and so I'm here just simply to listen today. And we have an outstanding group of panelists. I will be introducing those. They'll each speak, and then afterwards, of course, we'll have time for your questions. Our first speaker is David Bookbinder, who is the chief counsel of the Niskanen Center. After practicing law at Paul Weiss, he entered the public interest sphere. Mr. Bookbinder has served as Sierra Club's chief climate counsel, initiating and managing Massachusetts versus EPA. He's also represented the environmental community in litigation over California's greenhouse gas vehicle standards and brought In re Deseret Power, which effectively imposed a moratorium on new coal-fired power plants. And Mr. Bookbinder led Sierra Club's work on judicial nominations, an area of an executive branch action that last year was near and dear to my heart. He was involved in litigation over the constitutionality of recess appointments for federal judges and was counsel in In re Cheney. Mr. Bookbinder has helped lead efforts on both global warming legislation and greenhouse gas regulation under the Clean Air Act, and has testified before House and Senate subcommittees or committees on these issues. And he may have been the only person ever to be invited by both Senator Barbara Boxer and Senator James Inhofe to testify. He has advised states as to Greenhouse Regulatory Authority as well. A summa cum laude graduate of Princeton, a University of Chicago Law School graduate. He's also taught courses on environmental law and litigation at Georgetown and William & Mary. Please join me in welcoming David Bookbinder.
Thank you. Thank you all for coming. And I want to thank the Federalist Society for having a panel on an issue that obviously is of great importance to the legal community and to the nation as a whole. I'm going to start by talking about the nuisance cases. I am counsel in one of the nuisance cases. It's the one pending in court in Colorado. It's the County of Boulder versus Suncor. And that one, we just finished the briefing as to whether or not it's going to be in federal court or in state court. We filed it in state court. Defendants removed. We just finished the removal remand briefing, and eventually we'll find out where we're going to be litigating. The first thing I want to talk about on the nuisance cases is they are not what everyone appears to think they are. They are not climate policy cases. I do climate policy. I spend most of my time in Washington working on federal legislation, on carbon tax issues, keeping an eye on the regulatory program. Earlier this week, I was talking to the industrial energy consumers of America, who are all the large power users, about things like what would a border tax adjustment look like in a federal carbon tax bill. That's climate policy. That's national and federal climate policy. These nuisance cases are not climate policy cases. These cases are local governments faced with very, very large bills for climate adaptation. And whether it's sea level rise on the coastal cities and the coastal states, since now we have an entire state, the state of Rhode Island, bringing such a case, what we have is enormous amounts of expenses that are staring these local governments in the face. And the question is, how are they going to pay for it? And they have two choices. The two choices are they either tax their residents or they seek to shift some of the responsibility to the fossil fuel companies. And the theory in those cases is you made these products. At some point, you became aware of the impacts these products would have when they were used. You did not reveal that information. You concealed it, and in some cases, at worst, you might have affirmatively misrepresented these things. And now, when you've all the oil companies, for instance, have said, yes, our products create climate change. We know that. Their business plan is to make more and more of these products, making these injuries worse and worse. And let me just flip for a second to the other sorts of injuries. We brought the first case that was in the interior United States, not a coastal city or a coastal state. And it's interesting. The counties we're representing, San Miguel County, Boulder County, and the city of Boulder, are facing lots of expenses for things that are absolutely traditional government functions. Road maintenance. Most of the roads in counties in Colorado are dirt roads, and when you have an increased freeze-thaw cycle, in other words, you have more times when temperature during the winter is below freezing, then it rises above freezing and then goes below, et cetera, that wreaks havoc with dirt roads. It's just astonishing, and that leads to increased road maintenance costs. Very simple, traditional. You can't get a more traditional government function than keeping the roads in shape. Wildfire prevention, wildfire response, all these things are local government responsibilities, and they have to figure out how they're going to pay for these things. And so they've come up with a theory. Well, why don't we see if the people who made these products, knowing that this was going to happen and not saying anything about it, should be held responsible for some of the claims. Earlier this week, there was an astonishing development in these cases that has not gotten a lot of play, which is until this week, every single one of the cases was brought by a governmental entity, whether a city, a county, or a state. And I think it was Wednesday, possibly Thursday, the first private plaintiffs sued. So now, and what's more, the private plaintiffs that sued were the West Coast Fishermen's Associations. And if you can imagine, I don't think you can imagine a more conservative group than the fishing industry, if you've ever dealt with them. They are hardcore anti-environmental, they are extremely conservative, and the fishing industry has now said the fossil fuel industry is ruining our business, and we want to be compensated for it. This is a watershed moment in these cases. The consequences of this, I don't think, can be underestimated. I am aware of several other industries, private industries, that are contemplating such claims. The fact that this one was the first filed is very interesting. It gives political cover to a lot of industries that were a little nervous being the first ones out of the box. And I think that will be the next set of developments in the nuisance cases. Will be more and more of these of private parties bringing them. And let me just add one more thing, because I suspect we're only supposed to go for 5 minutes, and I probably am hitting that limit. The fishermen brought a public nuisance claim and a couple of other claims. So they brought a public nuisance claim because their catch, particularly it's the Dungeness crab subset of that industry that is the basis of the claims, that it's ruining the crabbing off the West Coast. Those crabs are in public waters. They're in state and federal waters. It's a public nuisance claim. The next set of plaintiffs who will bring private nuisance claims will take a step that I don't think a lot of people are prepared to deal with, because there's been a lot of talk out there, not involving the plaintiffs in these cases, but a lot of other people and pundits saying, well, eventually at some point if they succeed in these cases, then the oil companies will come to the table and we'll get a carbon tax, and Congress will immunize them against this liability. And whether or not that's true, that's an interesting idea. That goes right out the window if you're dealing with private nuisance claims. The Supreme Court and many state Supreme Courts have said a private nuisance claim is a form of property, and the legislature cannot eliminate it unless it pays just compensation. So we're on the cusp of a situation where the claims that are going to be filed in the future by private industry and private actors are not anything that can be eliminated in a political settlement. So with that, I will kind of resume my seat here and turn it over to the next speaker.
Our next panelist is Eric Grant, who is Deputy Assistant Attorney General in the Environmental and National Resources Division of the United States Department of Justice. Mr. Grant earned both his undergraduate and law degrees from the University of California, Berkeley. He served as a law clerk to retired Chief Justice Warren Burger and Associate Justice Clarence Thomas. Over the course of his 28-year legal career, Mr. Grant has argued cases in the United States Supreme Court, the California Supreme Court, and numerous other federal and state appellate courts. He has published on constitutional law and taught as an adjunct professor at UC Davis School of Law. Following 2 decades of private practice in Sacramento, where he focused on environmental law and other complex civil litigation, Mr. Grant last year joined the Environmental and Natural Resources Division of the Department of Justice. As Deputy Assistant Attorney General, he is in charge of appellate and Indian-related litigation. Please join me in welcoming Mr. Eric Grant.
Try to get a timer here so we stick to 5 minutes. Thank you, Judge Bush, for that kind introduction. My thanks also to the Federalist Society and to the Environmental Law and Property Rights Practice Group in particular for inviting me to be part of this panel. I'm on the leadership team of the Justice Department's Environment Division, newly headed by Jeffrey Clark, whom many of you know. I need to say that my remarks do not constitute the official views of the department, which speaks principally through its court filings. But I will discuss some of those filings, and I hope you will get a good sense of the department's views about climate change nuisance suits. At Judge William Alsup's invitation, we expressed those views in our amicus brief in the nuisance lawsuit brought by the cities of Oakland and San Francisco in the Northern District of California. That brief is available as part of the convention's CLE materials, and I commend you to read the entire thing. That brief made 3 points. First, the federal common law of nuisance affords no remedy to plaintiffs seeking relief from alleged global climate change. Such relief would require judicial creation of a novel remedy with no statutory basis. And such a remedy would implicate critical policy judgments best made in the first instance by Congress. Second, any federal common law claim that might exist is displaced. Although the cities cast their allegations in terms of the production of fossil fuels, their claim of injury is legally and factually tenable only to the extent it's predicated on emissions of greenhouse gases from the combustion of fossil fuels. But the Supreme Court's decision in American Electric Power Company versus Connecticut teaches that Congress has addressed greenhouse gas emissions in the Clean Air Act, granting authority to address such emissions as a matter of federal law, not to the courts, but to the executive branch. The authority of Congress and the executive branch over foreign relations, including the power to negotiate with other nations to address climate change on a global scale, is another important reason why these nuisance claims are unsuited to adjudication under federal common law. Third, these nuisance claims are unsuited to such adjudication because they violate constitutional separation of powers principles and because they're non-justiciable. Virtually every individual company and government across the globe emits greenhouse gases. If two cities in California may properly allege injuries from climate change in federal court, then so may every person on the planet. Federal courts are poorly equipped to handle this multitude of cases and the associated complex scientific and economic judgments and technical judgments that are part of them. Nor should courts be the institutions designated to resolve the serious policy questions that arise in these cases. Instead, balancing the nation's energy needs and economic interests against the risks posed by alleged global climate change should be left to the political branches of the federal government in the first instance. We are pleased that in rejecting the city's nuisance claims, Judge Alsup expressly cited our amicus brief. Not to be outdone by Oakland and San Francisco, the city of New York has brought its own climate nuisance suit in federal district court. That suit raises a slightly different issue, whether plaintiffs may combat alleged global climate change through state law claims. But the outcome was the same. Like Judge Alsup, Judge John Keenan of the Southern District of New York ruled that they may not, quote, to litigate such an action for injuries from foreign greenhouse gas emissions in federal court would severely infringe upon the foreign policy decisions that are squarely within the purview of the political branches of the U.S. government, unquote. More generally, global warming and solutions thereto must be addressed by the other two branches of government, and they are not for the judiciary to ameliorate. We heartily agree. That brings me to the supreme exemplar of the climate change nuisance suit, at least insofar as it's a nuisance to Justice Department lawyers. That is Juliana of the United States, as it is known in the trial court. In this lawsuit, District Judge Ann Aiken has already recognized a Fifth Amendment substantive due process right to a climate system capable of sustaining human life. And in ruling that the plaintiffs satisfy the redressability prong of Article III standing, the judge has determined that she is empowered to redress plaintiffs' alleged injuries by ordering defendants, and seriously I'm quoting here, ordering defendants to cease their permitting, authorizing, and subsidizing of fossil fuels and instead move to swiftly phase out CO2 emissions, as well as take such other action necessary to ensure that atmospheric CO2 is no more concentrated than 350 parts per million by 2100. She can do that. To put an end to this lawsuit and forestall the scheduled 10-week trial that the plaintiffs bill as the trial of the century, the department has filed no fewer than 4 mandamus petitions in the Ninth Circuit, 1 mandamus petition in the Supreme Court, and 2 stay applications in the Supreme Court. In that effort, I feel like the title character in the biblical parable of the persistent widow. Jim Huffman has more on Juliana and similar cases in foreign courts, and so I'll yield to him.
Our next speaker is Professor Jim Huffman, who is Emeritus Dean and Professor of Law at Lewis and Clark Law School. Professor Huffman joined the law school faculty in 1973, was appointed acting dean in 1993, and dean in 1994. He returned to full-time teaching in 2006. Born in Fort Benton, Montana, Jim is a graduate of Montana State University, the Fletcher School of Law and Diplomacy at Tufts University, and the University of Chicago Law School. He has literally seen the world as a visiting professor at universities in New Zealand, Guatemala, and Oregon, if that counts as a foreign country. He was also a fellow at the Humane Studies Institute and a distinguished Bradley Scholar at the Heritage Foundation. He serves on boards of the National Crime Victims Law Institute, the Foundation for Research in Economics and the Environment, the Classroom Law Project, and the Rocky Mountain Mineral Law Foundation. An author of more than 100 articles and chapters on a wide array of legal topics, Jim is a member of the Federalist Society and former chair of the Executive Committee of the Federalist Society's Environmental and Property Rights Practice Group. Please join me in welcoming Professor Jim Huffman.
Thank you very much, Judge. It's a pleasure to be here. I'm sure I don't need to say that my views are not those of my colleagues at Lewis and Clark Law School, or of most of my colleagues in the Legal Academy. As was suggested by Eric, over the last few years, decade or so, there's been a literal barrage of lawsuits filed in this country and across the world, making various claims about rights that people have to be free from climate change or the effects of climate change, and therefore for courts to mandate that governments undertake various policies. And those claims are rooted in a variety of theories ranging from basic human rights documents of international treaties, et cetera, constitutional claims both at the federal and state level, and common law public trust doctrine claims. And I can't address all that, but I do want to focus on a couple. And first, before turning to Juliana and related cases, mention one international case, that a Dutch case that, if you're not aware of, I think you might find interesting. It's called Urgenda against the Kingdom of the Netherlands. And it was a lawsuit rooted in human rights theories and a lot of international agreements that the Dutch government has entered into, on the basis of which the claimants in that case argued that they had a right to be free from the effects of climate change, and therefore for the court to order the Dutch government to take greater measures than they had. Well, the Dutch government had already taken pretty serious measures. They had put into place regulations to reduce carbon emissions that were projected to achieve at least a 17% reduction from 1990, and was later, on reassessment, determined to projected to reduce climate or carbon emissions by 20%. Well, the trial court in the Netherlands ruled that that wasn't good enough, and that the government had to figure out how to reduce it by 25% based upon various scientific estimates from 350.org and other such places. And that case has, within the last 3 or 4 weeks, been upheld by an appellate court in the Netherlands. And there's been similar successful litigation in Pakistan and Colombia on similar theories. In the United States, the Juliana case is part of a quite sophisticated strategy pushed by something called Our Children's Trust. And their objective was to file cases either in courts or administrative agencies in every state in the union, and the federal government, with the theory being, and it's not a bad theory given the realities of our lives, that somewhere they're going to find a judge who takes the bait. And sure enough, right there in my home state of Oregon, they found the judge. So just a few words about the Juliana case beyond what Eric said. It's really rooted, they have two fundamentally different theories. One is the due process argument that Eric mentioned. Let me just quote a couple of things from the judge. Eric's already given you a taste. Here's a little more. She said on both of these claims, both the public trust claim and the due process claim, quote, "To rule otherwise would be to say that the Constitution affords no protection against a government's knowing decision to poison the air its citizens breathe or the water its citizens drink. So she really felt that she had no choice but to find these claims to have some viability. The due process, on the due process claim, her basic argument was, or her justification for ruling that there is such a due process right, was to cite the abortion cases and the gay marriage cases, same-sex marriage cases, as precedent for the position that she takes on due process. And she said, again to quote, "Exercising my reasoned judgment, I have no doubt that the rights to a climate system capable of sustaining life is fundamental to a free and ordered society." Well, it doesn't take a lot of imagination to think of a whole lot of other things that are necessary to a free and ordered society. But I want to focus mostly on the public trust doctrine because it seems to be a doctrine of which there's very little understanding and a lot of confusion. And it is the foundation of a theory that was originally promulgated by Mary Wood, who's on the faculty of the University of Oregon Law School, which she labels the atmospheric trust theory. The public trust doctrine it actually never existed under that terminology in English law, but it existed in principle and was adopted in this country from the beginning of the state governments. And it is a question of state law, although there's a lot of arguments that it's also a question of federal law. And the rules were basically applied to very narrow public uses of navigable waterways, fishing and commercial navigation. There were a few cases that also referenced bathing, but that was it, and that was it right up until the middle of the 20th century, or a little past the middle of the 20th century. Now, there was some variation from state to state, as you would expect, and as there should be, because it is a question of state law. But that was the focus. It was on navigable waters and those very limited but important public uses. In 1969, Professor Joe Sachs, some of you will remember Joe, wrote an article about the public trust doctrine and suggesting that it might be a good foundation on which environmental efforts could get courts to take more action to promote environmental objectives. And it was a well-written and well-argued article, as all of Sachs's were. In 1980, he wrote another article, the title of which was something like Removing the Historic Shackles of the Public Trust Doctrine, which others might think of just overcoming precedent. And Sachs argued that if we could just remove these constraints of what the doctrine has been throughout the history of American common law in the states, it could become a very effective doctrine. And so Mary Wood really took him up on that and said, let's call this thing an atmospheric trust doctrine. And on that basis, we can order governments to take all kinds of measures that they have chosen, in many cases, not to take through the political branches of the government. The power of the public trust doctrine, and why I think the environmentalists have long tried to rely on it, is it insulates government from any takings claim, because by definition, a public trust right predates everything. It's a right that existed in the nature of popular sovereignty, and therefore, takings claims are off the table. And that's a powerful incentive to get courts to try to rely on it. The last point I want to make, and this is a point that Eric has made as well, is what's really important in these cases. I think on the merits, it's beyond my imagination, although many things have happened beyond my imagination, that ultimately, if this gets to the United States Supreme Court, they would uphold the kind of theories that Judge Aiken has articulated in her preliminary opinion in federal district court. But what's more significant to me is the separation of powers implications of these kinds of cases, because it's putting the courts in the position, asking the courts to be in the position of mandating action by the executive and legislative branches of government, which those branches of government are on a regular basis considering and choosing to take or not take. And it seems to me under the separation of powers doctrine in this country, that's just got to be unacceptable. My colleagues who support these theories argue that, well, this is a common law doctrine, and common law judges, as we were taught in law school, the common law is judge-made law, not legislative-made law. But that's a oversimplification of what common law judges do, in my judgment. There's a certain amount of adaptation that the law has to take, but that it's not an authorization to make law. And that's really what Judge Aiken ultimately says in her opinion in the Juliana case. She quotes John Marshall, who we're going to hear more about later today, and the widely and frequently quoted language from Marbury against Madison that it is emphatically the province and duty of the Judicial Department to say what the law is. Well, I never understood that to mean to say what you want the law to be or to make the law. I always understood that to be a simple reaffirmation of the concept of judicial review. Ultimately, we can understand Judge Aiken's position in this quotation from the end of her opinion, and she cites another Federal Circuit Court judge, Alfred Goodwin, who wrote, when he was an Oregon State Supreme Court judge, an opinion of somewhat similar vein on the access to coastal areas in the state of Oregon. She says, quote, "Federal courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it." I think we'll suffer a lot more for the kinds of decisions that Judge Aiken is proposing that the courts ought to make. Thank you.
Our final speaker is Mark Smith, who is founding partner of Smith Valliere PLLC in New York City. Mr. Smith is an NYU School of Law graduate who clerked for Judge Brooke Bartlett of the United States District Court for the Western District of Missouri. He practiced at Skadden Arps and also was a partner at Kasowitz, Benson, Torres, and Friedman LLP before founding Smith Valliere in 2007. Mr. Smith has tried jury and bench trials in state and federal court and has litigated complex cases involving billions of dollars. As co-counsel in a federal jury trial, he represented a client who won a multi-million-dollar judgment in a significant civil rights case reported by the New York Times as the largest of its kind in New York history. He was also involved in an important no-fault insurance trial involving $23 million. He's represented Texas legislators as amicus in the U.S. Supreme Court and represented African-American women seeking to start a hair braiding company in a highly publicized constitutional challenge to New York State economic regulations. But particularly relevant here, Mr. Smith represented New Yorkers in a constitutional challenge to New York's participation in the cap-and-trade process called the Regional Greenhouse Gas Initiative. Please join me in welcoming Mr. Mark Smith.
Thank you, Judge. For those of you who are concerned with the worldwide environmental dangers of carbon dioxide, I welcome all of you to hold your breath throughout my remarks this morning. My response to these climate change lawsuits really goes back to around 450 AD in the Middle Ages and the Dark Ages in Europe. During the Dark Ages and the Middle Ages, many bad things occurred, we know from our history books, in the natural world. The Black Plague, falling trees, avalanches, earthquakes, animal attacks, and all sorts of superstitions about witchcraft and the devil running amongst European populations. A scary time in that period of world history. And many of these unfortunate natural events were really unexplainable to humans at the time because they lacked the benefits of modern science. But humans, by their nature, are uncomfortable with things that they cannot explain. They want to know there's a cause and effect. And when bad people are hurt, they want to know why bad people who do good things are hurt by bad people who do bad things. So in the medieval times, there was a solution for instances of animal attacks and natural disasters and the humans that sought explanations. And that was the actual trial of animals and inanimate objects. During this period of medieval history, there were hundreds and hundreds of trials involving pigs, bulls, cows, eels, mice, leeches, rats, locusts, and the list goes on and on and on. But in addition to the animals being tried, there were also trials involving inanimate objects who were put on trial for being guilty or not guilty, for causing the problem and the failure of the crops or not. Those inanimate objects that were tried in medieval Europe included rocks, trees, and mic drop, glaciers, just like we're talking about today. Now, by virtue of the word trials, I mean literally trials. There were prosecutors. There were defense counsel. There were witnesses. There were judges. There were extensions of time to allow the animals to respond and show up in response to notices. There were jails designed for the inanimate objects and the animals who were put in there pending trial. There were convictions, there were sentences, and yes, there were even pardons of the animals and the inanimate objects, including, again, rocks, trees, and the glaciers. Now, I first heard about the history of animal and inanimate object trials from a law school classmate, Paul Berman, who wrote an excellent law review article in the New York Law Review back in law school. And this was before he went to clerk for Ruth Bader Ginsburg on the Supreme Court, and this was before she was notorious. And I remember thinking at the time of Paul's article, wow, I'm glad that moving into my career at Skadden Arps, I don't have to worry about the courts getting involved with superstitions and mysticism ever again in my life. Under the color of law, how wrong was I? Because now we have lawsuits involving climate change, putting on trial CO2, carbon dioxide, which last I checked is what we all exhale, among other things. A natural phenomenon, no different than the natural phenomena that were tried in medieval times. Now, I'm not going to get into the merits and debate about the science of climate change, beyond saying this. Thursday in New York City, the meteorologist and the weather forecast said we might have a light dusting of snow. Thursday afternoon, we had 6.5 inches of snow in Central Park, and Bill de Blasio, who signed on, by the way, to all these climate change lawsuits, could not be more angry at the weathermen, and he excoriated them for getting the forecast wrong 8 hours before the snowstorm. Well, needless to say, for a profession that cannot predict the weather 8 hours in advance, I'm not inclined to repeal the Industrial Revolution based on their models. So what are these climate change lawsuits today really about? Well, they're not about the law, and they should not be treated as law, and they should not be treated and analyzed in a way litigations are usually analyzed. These are propaganda devices, polemic devices designed to effectuate and change the political narrative of not just political leaders and not just the covers of newspapers that breathlessly report these children crusaders are changing the world and saving the globe from climate change and CO2. No, this is about weaponizing the courts for a political gain. That's what this is all about, and it should not be treated as law. And the left, of course, in America is known for this. They have a lot of success. We have nationwide rights to abortion because of the courts. We have gay marriage in America because of the courts. We have free public schooling education for the children of illegal immigrants because of the courts, and the list goes on and on. I don't need to recount them here to you because you're familiar with them. So these lawsuits about climate change simply provide the excuse to talk about a left-wing agenda item, and it has worked. In fact, The fact that this morning we are talking about the agenda item of climate change and suing capitalism and suing businesses for being productive. And mind you, the fossil fuel companies, the oil companies make the fuel. They don't burn the fuel they make. Those are burned by the cities and the towns and the plaintiffs that are suing them. And the CO2, mind you, is not from fossil fuels. It's from the burning of fossil fuels, burned by the very same Bill de Blasios and liberals that fly around on their private jets, burning the fossil fuels, which are actually the cause of the problem. Now, this panel today, and I will close with this, should not be taking place at a legal conference at the Federalist Society. A discussion of these lawsuits should really be taking place at a conference of marketing and public relations professionals, because that's what they really are. And by putting the inanimate object CO2, or carbon dioxide, a natural part of our climate and a natural part of the human existence, on trial in a courtroom is essentially and at best a feel-good attempt to advance a political agenda where they're political leaders. But the fact that they exist and are being taken seriously really makes me wonder, how far have we as a society advanced since the Middle Ages, when we used to put rocks, animals, and yes, glaciers on trial for things we did not understand about the human and the natural condition of our planet? Thank you.
Can you hear me from here? Now that things have livened up a bit. I'll start the questioning out, and Mark, your remarks sort of reminded me of maybe this issue, and I wanted to direct it to Eric first. So in the Giuliani case, as well as in cases brought against the oil industry defendants by the cities of Oakland and New York, it appears to be taken as a given that fossil fuel consumption is the direct cause of many serious bad environmental effects. In the oil industry cases, the decision not to dispute the facts is understandable because those cases involve motions to dismiss. But in Giuliani, that's a summary judgment motion. And can you comment on the federal defendant's decision apparently not to even attempt to challenge the alleged facts linking fossil fuel consumption to various climate events?
Certainly. Two aspects of that. One, the answer in that case was filed in a previous administration and reflects the views of that administration. And two, and more importantly, our very simple argument is we win as a matter of law. No matter the truth of the allegations of the plaintiff's complaint, there is no substantive due process right to a stable climate system. There is no public trust doctrine that allows a court to order federal officials and agencies to reorder the national economy. So we think that's pretty simple, it's pretty clean, it's a matter of law. We deserve summary judgment, and as we've asked the Ninth Circuit 4 times and the Supreme Court twice, this lawsuit should be dismissed.
Does anyone else have any comments on that question? Go ahead.
Two things. The science is not really at issue, certainly as Mr. Grant pointed out in the nuisance cases. It's not because it's at the motion to dismiss stage. It's because Ted Boutros, who won a great victory yesterday for freedom of the press, got up in a courtroom in San Francisco and for 2 hours, through dozens of PowerPoint slides, put up the IPCC 5, the Intergovernmental Panel on Climate Change 5 report, and said, we agree with this statement, we agree with this statement. We agree with this statement. We endorse this statement. For 2 hours, stood there and talked about how they endorsed it. And if you don't think that's dispositive, you should read the climate reports from the defendants, their climate status reports, their annual reports, their securities filings. All the defendants have completely admitted, yes, we make products that are altering the climate. Now, it's interesting that the federal government, yes, the answer in Juliana was filed, I think, in December of 2016. 2 years later, the Justice Department has not seen fit to submit an amended answer in that case. And I think that's also very interesting, that they've not chosen to dispute any of the facts even on the eve of trial. And in fact, they asked the judge to not have any of the plaintiffs' climate experts testify because they've conceded all the scientific issues in that case. So I think it's very interesting. The science stuff is not actually going to be as much of an issue in either set of cases, although eventually in the nuisance cases, there will be the big issue, the very, very interesting issue of attribution of particular climate injuries in particular locations to climate change. And that's going to be a very fascinating question if we get to trial.
Jim or Mark, do you have any thoughts?
I would just second what Eric said. It seems to me the science stuff is really not at issue in the Juliana case. What's at issue is whether or not these rights exist as a matter of law, and whether or not it's the role of the courts to be effectively acting on whatever the science stuff says. It's not within the judicial competence. It's not within the judiciary's constitutional role. So those are the issues to me. It's not whether or not the science is right or wrong.
I guess I'll just add in the Scopes monkey trial, evolution lost. So courts don't always nail signs correctly. So whether or not this judge will nail signs correctly or whether or not the other enlightened members of deep state in Washington have got it right, I can't speak to that right here and right now. But everything that both, I think, the positions taken in these cases should be taken, I would say, with a healthy dose of skepticism based on the history of some of this.
Well, I'll be happy to continue on with my questions, but I think probably some people in the audience may have more burning issues they'd like to raise. So we'll go ahead and open it up to some questions.
Thank you. I'm not sure the extent of the defendant class, Mr. McCliner or Mr. Grant, in these cases. I'm wondering if you've included all the foreign oil companies that really don't do business here. I don't know, Pemex, I guess Pemex does. You've got Petrobras, you've got Gazprom, Chinese oil companies, Sinnox, something like that. I wonder if you join them as defendants, because from what I understand, that's where the massive amounts of carbon increase are coming from, these China and other developing areas. The United States has actually done a pretty good job of reducing emissions. And also, whether you've included Oakland and San Francisco themselves for cutting down massive amounts of carbon dioxide absorbing forests when they develop their cities, and whether anybody's brought up a Rule 19 necessary and indispensable party defense for not joining all of these other defendants. I'm just mostly interested in the Rule 19 issues. It's interesting. The various groups of lawyers who are doing the nuisance cases have very different theories about what set of defendants they want to be suing. It ranges from one group of lawyers who've brought the most of these cases, have named an endless string of oil and gas companies and coal companies, and John Doe's 1 through 100. Another lawyer, the second kind of group of cases, is brought by a lawyer who's New York, Oakland, San Francisco, King County in Washington State, has sued repeatedly the set of defendants of 5 oil companies. And no, there's been no Rule 19 issue there as to adding necessary parties. And in Colorado, we've simply sued 2 oil companies, and we seek only several liability. We're seeking only to establish the liability of the particular defendants that we've sued, and for their share of the problem, not going for joint and several liability as in the other cases. So that's the short answer, and there's been no discussion. I don't think any motions filed in any of the cases about Rule 19. They're all either went straight to the first issue is, of course, the whether they're in state and federal court. The defendants in the cases with the long kind of laundry list of fossil fuel companies, the Ninth Circuit is now is addressing the question: do these belong in state court, or do these belong in federal court? Which is a fascinating issue. Two judges in the same courthouse in San Francisco. Judge Alsup said these are federal, and I'm keeping them. Judge Chhabria said these are clearly state, and I'm sending them back to state court. So that's where we stand on those issues.
Justice Department's defending the United States, the President, several presidential offices, and more than half the cabinet-level agencies. So we think there are enough defendants in these cases. And we think that in pleading potential additional defendants takes away from the simplicity of our argument that as a matter of law, these claims simply don't exist.
Sure, go ahead.
Hi. Can you hear me okay? Yeah. Sorry, Chris Hollinger from Virginia Beach. Also a question for Mr. Bookbinder. Your statements just a second ago were kind of getting to this question for me. Could you explain a little bit maybe about how the nuisance lawsuits intend to try to, I don't know if the word is allocate or apportion responsibility? You mentioned that in Colorado you're only suing 2 oil companies. How do you figure out those 2 oil companies' share of the global problem of climate change that's caused by the actions of every human being on Earth and every company that you can possibly name?
Yes. The theory on them is simply that the percentage of fossil fuels that they're responsible for producing and marketing, if we look at the injury created by the use of all fossil fuels, since the point when those defendants became aware of the problem, and then apportion it almost certainly along the lines of their share of what they produced and marketed, we think we can narrow it down to a pretty easy set of numbers for the court to handle, especially after we go through the discovery process.
Get him in front. Oh, okay.
Thank you. Brooks Harlow, I practice here in the D.C. area, and thank you all for accepting my reprints of my CO2 article from the Energy Bar Journal. I see the science as a huge issue, and I addressed a very narrow slice of that. The first issue that you've got is the Earth's climate is unquestionably changing. I mean, anybody who denies that, I write them off, okay? It changes all the time. We've gone from literally snowball Earth, where the entire Earth is covered with ice, to totally ice-free Earth over 5 billion years. In the last 200 years, more recent memory, we've had a continual increase in the global temperature since we came out of the little ice age, and there were quite a lot of historically known variations in climate for the last 2,000 to 3,000 years, where we have historical records. And the problem that I see initially is nobody understands why the Earth's climate changes the way it does. So we don't have a baseline. The second issue I see, and this is the subject of my article, is that the concerns about significant climate change, everybody knows you put in the CO2 we've been putting in, it may raise the temperature 0.5 degree or so, which probably isn't enough to cause any problems that are raised in these suits. The concern is that you then get a feedback, it's a positive feedback, and it's significant. So a little bit of increase creates a big increase. And that's based on models.
Have you got a question for the panelists?
Yeah, the question is, how do you see getting around the problem of A, a lack of baseline, and B, how do you get into court with models and proving things on models that have never been tested in real life?
I assume that's a question for me. We don't foresee any problem with the first step of that, which is that we've got anthropogenic climate change, human-created climate change, created and caused largely by the use of fossil fuels. We don't think that's a problem. The defendants have already conceded it. Every government on the planet, including this government, has said, yes, that's what's going on. The more interesting problem, as I think you pointed out, is how do we show, for instance, that the freeze-thaw cycles in San Miguel County, the increase in number of the cycles is attributable to climate change? And the answer is we are confident that we have the scientific testimony, and we are looking forward to going in front of a trier of fact on this. It's interesting. Climate has already been tried in the courts. In 2007, the auto industry sued all the states or 4 of the states that adopted California's tailpipe CO2 standards. And we took it to trial in Vermont. And the auto industry dragged out their climate scientists, saying, no such thing, not happening. And on cross-examination, we sliced and diced and they let them out in body bags. And the judge's decision is available. It's a case called Green Mountain versus Crombie, in a case brought by the auto industry in a courthouse that they chose. So yes, there was that. We've already gone through this once on the general climate issue. And on the specific attribution at the level we're looking at, that's going to be a really, really interesting exercise. There'll be experts on both sides, and we're confident we can prove it.
I'd like to add on, as a practicing litigator that spent 20 years litigating literally billions of dollars in cases in all sorts of contexts, the problem I think that your question raises is that in these cases, and this is mission critical to understand, there really is no other side. And what I mean by that, if I can draw an analogy, as to how government collective bargaining agreements get negotiated, and then draw the analogy. When you have government workers are negotiating pay raises with government workers on the other side of the table, like elected mayors and politicians, there's no other side to the debate. There's no, I want to pay you $1 and you want $1 million and we meet in the middle. When you have government negotiating, or either government negotiating with government, or government litigating against government, there's no other side. So in these cases you have lawsuits brought by public interest lawyers that want to change the world, can't do it through the democratic process and use the courts to do it, working alongside with plaintiffs' lawyers that just want the money, which is understandable, right? They sue government agencies run by deep state government regulators that went to work for the EPA, except for Eric, because they wanted to change the world. That's why they took the job at EPA in the first place, right? This is their dream job. And then they sue these people who want to change the world through their regulations. And then you have a government judge, most of whom are scientifically illiterate, looking at this case. Next thing you know, you have a courtroom full of everyone on the exact same side saying, we want to regulate, we want more government, we want higher taxes, we want more lawsuits, we want more lawyers. And guess what happens when you create that sausage? Out comes the result of, there's a problem here, we need more lawsuits, more damages, more et cetera, et cetera. So the reality is when I see these contrived lawsuits, essentially government suing government in front of government, I kind of have a feel of what's going on here. Again, it's why FDR said you can't let government employees negotiate government contracts with government employees. They will always give themselves raises. This is a version of that.
I'd like to respond to one point. There are no government versus government cases anywhere in this, in either of these two sets of litigation. The nuisance cases are, until this week, just government against the fossil fuel industry. Now it's government and private industry against the fossil fuel industry. And in the Juliana case, it's individuals against the federal government. There are no government versus government cases in any of these.
Right, but the point is, even in the cases where you have government suing private actors, those cases are all using government decisions made years ago, either by EPA officials about that carbon dioxide is a pollutant under the Clean Air Act or whatnot, or other decisions made, for example, in San Francisco by a judge. So these now become established scientific fact that all this stuff is true. So when the government sues a private actor, they just say, well, we already know the EPA decided this. These European scientists over in Geneva decided this. This is established fact. and then they come into court against the private actors, so it's really an unfair fight. So even if it's not technically government versus a government in a particular case, the reality is the government is using all of that government apparatus and all that government conclusions and findings to beat the private litigant over the head, as this is established by our better people at the EPA than we are.
David, I will give you one short response, and then we
Two
have to
things.
move on.
As I said, the defendants have up and down and in and out repeatedly conceded the science on this issue. So that we think is closed. The second thing is, in the nuisance case, for instance, in my nuisance case, we're not seeking any injunctive relief, and we're specifically saying we're not asking you to reduce your amount of production of fuels at all. We're simply saying we want you to pay for the damage that those fuels cause.
I think you're next.
Hi, my name is Devin Watkins from the Competitive Enterprise Institute. My question is to Bookbinder. As far as I'm aware, the Clean Air Act prohibits local and state, or preempts local and state jurisdictions from regulating the emissions of carbon dioxide and other such emissions. So as the burning of these fossil fuels, and so the emissions of them is, I believe, a core part of your causation analysis, why isn't that preempted under the Clean Air Act? And the others can respond as well.
The answer is the Clean Air Act only preempts state and local governments from regulating mobile sources, basically vehicle tailpipes, because they want to have a limited number of standards for a national industry. States are completely free to regulate carbon dioxide from stationary sources, which is why we heard about the Regional Greenhouse Gas Initiative, where 9 states regulate the emissions from all the fossil fuel power plants in their states. That's why Oregon and California have a low carbon fuel standard, which mandates the amount of CO2 that can be emitted when you burn the fuels. That's why many states have 37 states have renewable portfolio standards, mandating the amount of CO2 that can be generated by power produced in that state. That's why 3 states have laws saying you can't sell electricity in our state that's been produced by, if you exceed a certain amount of CO2 in generating it. So the answer is states are completely, totally free to regulate carbon dioxide from any and all sources except tailpipe sources. And that's why you don't have separate state standards for vehicles.
Any response?
In a properly implemented federal system, state and local governments are preempted from regulating conduct outside their borders, and I think in these cases, conduct outside the borders of the United States. And that's one fundamental problem that we've identified with these nuisance lawsuits, that the judges in 50 states and 93 federal districts are purporting to essentially regulate conduct that's taken place all over the world for decades. And Mr. Bookbinder said that these are not climate policy cases, but the cities of Oakland and San Francisco, just by themselves, have asked for $1.3 billion in their nuisance lawsuit. And if you start adding those up for every municipality on the West Coast, and I guess now we're starting to get municipalities in the interior of the country as well, that's crushing, punishing liability for an industry that Judge Alsup, I think, properly recognized is in part responsible for us having a modern economy.
And I should add, from the Competitive Enterprise Institute did an excellent job on this. They pointed out when they analyzed the municipal bond offerings by the cities that were suing, over the destruction of their land and property and values, the oil companies. When the Competitive Enterprise Institute looked at the bond offerings that they were floating, it turns out apparently that the amount of damages that were anticipated to be suffered by these cities were not as robust. In other words, they were telling bondholders apparently that maybe the damages to their cities are one thing, and the damages they're claiming in court may be a little bit bigger. But again, that's the research done by the Competitive Enterprise Institute, but you may want to check that out if you want to see whether or not they're squaring their circles in the various legal proceedings. Do you have one? Right there.
Good morning. My question is also for Mr. Bookbinder. You drew I know you're not surprised to hear that.
That's what you get when it's 3 against 1.
That's right. You expected this. You drew a distinction early on between nuisance and climate policy, and I think litigation between private actors, it makes sense maybe to characterize it as nuisance. I'm more curious about your thoughts on the Juliana case. First of all, if or when Judge Aiken decides that the plaintiffs are entitled to relief, presumably she enters an injunction and maybe retains jurisdiction as policing the government's efforts to comply. At that point, is she not kind of, as a practical matter, dictating policy to the policymaking branches? And secondly, what are your thoughts on the substantive due process theory there? Do you think there is a right to any specific kind of climate? And if so, how do we define that? Is it a right, recognizing that there were multiple ice ages and thawing periods and there was life during colder and warmer periods? Is it a right to the climate that existed throughout history until we started burning fossil fuels? Is it a right to the climate that existed in the 19th century? Is there any non-arbitrary way to define such a right?
That's an excellent question. I'm just, rather than leaning towards that mic, just giving me a bit of a neck ache. Those are terrific questions. And let me start by saying, I'm going to address the remedy issue first. Actually, no, let's do the substantive claim. I wrote an amicus brief on behalf of the plaintiffs in Juliana in the Ninth Circuit on simply the issue of the public trust doctrine. We did not take a position on the substantive due process claim, which is a huge uphill climb. I mean, just no kidding. The chances of them ultimately succeeding on that claim in the Supreme Court, I think, are very, very small. Which I don't think comes as a surprise to anybody in this room. I think the remedy question is really, really interesting as well, because what exactly do you want the judge to do when the defendants are, as Eric points out, virtually every government agency and virtually every action they've taken in any way dealing with fossil fuels for the last, Eric, 30 years, 40 years? Some very long period of time. And what the plaintiffs have said is, throughout the court papers, and again, Eric, if I say something wrong, please correct me, is, hey, we're not going to propose a remedy. We want the judge to find that there's this constitutional right, find that the defendants have violated, and then let the defendants come up with a plan for how they're going to regulate to, using their existing regulatory authority, to remedy that violation. Eric, am I correct? And please, you're the expert.
Well, the bait and switch in these cases is that to have Article 3 standing, plaintiffs have to have redressability. So at the outset, they have to be able to show that the judge has the authority to order a remedy that will remediate their alleged injuries. So at the outset, they say that, and then later when the United States goes to the higher courts, they like to say, "Oh, we don't have any proposed remedial plans. That'll just happen at some later stage."
Yeah. So I think it's fraught with all sorts of big constitutional issues here. I think the separation of powers question is an extremely real question. The judge kind of very confidently said, "I'm pretty sure I can deal with this." If it gets to the point where she, the trial goes forward and she gavels down and say, "Yes, I find there's this right and the government's violated it," and then what am I supposed to do about it? I think then it might occur to her that she's got herself a whole new and interesting set of problems, because what can she order federal agencies to do? And more importantly, more interestingly, in the context of finding a constitutional violation and trying to remedy a constitutional violation, can she cut back on agency discretion? And I don't know the answer to that. And if I were involved in the case, I'd be doing a lot more thinking about it. But I think there's some really very difficult questions ahead for Judge Aiken if she ever gets to the point of trying to figure out what a remedy is.
Let's go to the back.
Judge?
Someone from the back. I'm sorry, go ahead, Jim.
Well, I just want to add to this. Maybe it's more of a point you'd hear from an academic, but it seems to me there's a more fundamental problem implicit in the request that's been made of the judge, and that is that it's really asking for the court to recognize an affirmative right as opposed to a negative right. And this issue actually was discussed briefly in the prior session, and it was pointed out that some state constitutions have what were described as affirmative rights, meaning that that individuals have a right for the government to provide something that they aren't providing. Now, my understanding of, after 40-some years of teaching constitutional laws, is that at the federal level, at least, and in constitutional theory, we've always drawn a very strong distinction and clear distinction between negative and affirmative rights for this reason. Negative rights are rights which, in theory at least, can be enforced. You can tell the government to stop doing something it's doing, and if the government's willing, it'll stop, or the court will make it stop somehow. Affirmative rights are a whole different can of worms, and if you look at a lot of foreign constitutions, they're everywhere in foreign constitutions. Rights to education, rights to health care, rights to a decent level of housing, whatever. Those are rights that really are unenforceable even by the legislative and executive branches because they're dependent upon resources being available. And as soon as you say one thing is a right and something else isn't, you're mandating the way those resources are expended. And that is clearly a legislative function. It is not a judicial function. So to me, that is at the root of these problems. And if you look at the state constitutions that have affirmative protections for environmental rights, there's very, very few courts have found a way to make those enforceable, to say this is a right that we can actually enforce.
How about the one on the left in the very back? That's fine. We can go across. My left is different from yours.
Your left, my left. Good afternoon. Thanks for the panel. The question is this: since if we accept all the premises that you have, Mr. Bookbinder, then why wouldn't your plaintiffs be interested in going after comparatively India and China in some sort of foreign tort claim against those countries? Because if you look at the graph and what's happened since Paris, is that the U.S. is cutting back in as much ways as it can. India and China seem to be going forward and producing more, and they comparatively would be the worst actors, and so they would seek remedy in their courts if you assume Bernoulli's law and this is all affecting everybody equally across the globe.
I can't speak for the other lawyers involved in these cases, but again, trying to go to China and suing the Chinese government and Chinese court for climate injuries, that would be, I think, a complete waste of time and not get your clients the economic relief they're seeking. My clients got to fix the roads. My clients have to deliver water, and my clients have to prevent wildfires and then combat wildfires when they happen. And spending time chasing down foreign governments and foreign courts is not a very profitable way of doing that. It's interesting that when there is an issue came up early in these cases, the Norwegian oil company Statoil was originally named in some of these cases, but it's owned by the state of Norway. And the state of Norway it's a sovereign entity and has the right to remove to federal court. And so they dismissed Statoil out of these cases. So the idea of even if you can sue foreign governments in an American court, they have a right to remove to federal court, and the plaintiffs believe that these are state court claims and want them heard in state court.
Let's go over to the other side. Yeah, the guy in the back.
Thank you. Mr. Smith said at one point that these aren't real lawsuits, or they don't deserve to be thought of as real lawsuits. They're really public relations campaigns, or part of a public relations campaign and propaganda. And I guess I wonder, insofar as that's true, isn't this exactly the right thing for that side of the debate to be doing? A public relations campaign to hope, to try and get a law passed, I guess, ultimately by building a public support for their point of view. And as a corollary to that, I also want to ask, is it kind of giving away the game for the other side to if the response is largely focused on procedural technicalities or remedies and standing and redressability, and not sort of the broader substantive case at the heart of the debate?
Yeah, I think it's a great strategy for the climate change plaintiffs bar and the people on that side to be doing what they're doing. I think they're playing it exactly right, and I think we're living proof in this room that they're winning in one sense. I mean, this is the environmental law and property rights panel of this year's conference. So rather than talking about, let's say, advancing and enforcing the takings clause to advance property rights in America, we're talking about these lawsuits. And this is the kind of change in the narrative and the dialogue and the issues being discussed across the country that's taking place. So rather than talking about how do we strengthen private property rights, we're talking about an agenda of environmentalism that's really, in my view, anti-industrial revolution. So yes, I think they're doing exactly what they should be doing, especially since they're sort of nominally out of power in Washington, although one wonders how many people at the EPA voted for Donald Trump.
Why don't we go a little bit further in? Maybe the guy in the middle here who's got the beard, or well, you have two beards, so maybe they both get to answer ask a question.
Longer, so I'll ask the question. Since IPCC 5 came out, so I think there was a discussion of pre-IPCC 5 litigation with the trucking industry. Is anyone on the panel aware of many instances of depositions or cross-examination on the issue of the magnitude of climate sensitivity? I mean, I had an occasion where the Department of Justice, for some reason in the previous administration, decided to select as an expert a lead author of one of the IPCC chapters. So I got to ask him a lot of questions about this, and it was pretty revealing testimony. Why not depose more people and do more cross-examinations on climate sensitivity? The answers seem pretty revealing to me.
If and when that testimony is necessary for the cases, then that will happen. You don't generally start deposing people when you're dealing with removal and remand and motions to dismiss. So that will happen at the when we get into discovery and experts.
Let's go to the next.
Simple appellate lawyer, I win no matter what the facts are.
Let's go to the next bearded questioner.
Thank you, Your Honor. Tony Francois with the Pacific Legal Foundation. I've got another couple of questions for Mr. Bookbinder, but these are more like tactical litigation questions.
Away.
In your description of your client's claims, you talked a little bit about the defendant's knowledge of the effects of their products, which sounds a little bit like products liability as well. So I wonder if you could talk about what you think the differences are between a products liability claim and the nuisance claims. And then the other question I've got, that if anybody on the panel has information about, are you aware of anybody trying to intervene in these nuisance cases, arguing that they think they are better off on a net basis because of the benefits of industrialization, and that they should be heard, at least in fashioning a remedy that would take a different view what the remedy should be from the plaintiffs in those cases?
Let me start with the second part. I'm unaware of anyone attempting to intervene in any of the nuisance cases as a defendant. There were 2 or 3 trade associations, I believe, and Eric will correct me if I'm wrong, the National Association of Manufacturers and the American Petroleum Institute did intervene as defendants in the Juliana case, and when the judge denied the motion to dismiss and said we're going to discovery, they kind of ran away. And dropped out of the case. The first question is the differences between product liability and nuisance. I'm not really an expert on product liability, so what I would tell you would be, I would not be comfortable discussing product liability law. We brought these as nuisance claims and just did not bring product liability claims.
But I do understand what you're asking. You're essentially saying, how is this different than, let's say, the DES litigations that we saw, back in the day involving that drug? And there they, of course, essentially whacked up liability by market share allocation. But, of course, that was a very unique product. They knew the number of, I believe, women that took the DES pills. They knew the damages. They knew the market share. They had all that data. That's a much different situation than we have here, where every single person in this room is literally contributing to climate change by exhaling, not to mention the California forest fires and the foreign contributions and water vapor. And Buddy Menton over here of the Manhattan Contrarian blog, which is excellent, will give you a list of another 50,000 contributors to global warming if you buy into that CO2 causes all this. So that's why I think products liability can't work, because you can't be that specific with the causes.
Why don't we go over to this side, maybe here in the front. Over here. Yeah, at the very end. Or either one. Okay.
I'll try a question for Mr. Grant to make things a little different. Probably everybody in this room knows about the so-called endangerment finding that the EPA adopted in 2009 at the beginning of the Obama administration for reasons, again, many people know, and I've submitted on behalf of clients a petition to the EPA to revoke that. We consider it laughable and invalidated science. But my question to you is, first of all, what, if any, do you find the endangerment finding constraining you in either these litigations or other litigations, environmental litigations, that you are defending on behalf of EPA? And what, if any, plans are there to actually inject some real science into this endeavor from the side of EPA or Justice?
As to the first, the endangerment finding is there, adopted pursuant to the Administrative Procedure Act, and it will remain until it's changed pursuant to that same act. And we all the time deal with duly enacted rules and regulations that exist and will continue to exist until they're repealed. Now, when and whether and when it will be repealed, I don't know. Our clients at EPA have a lot on their plate, and if you have a petition pending, I'm sure they're considering it. And I hope that I won't have to defend an unreasonable delay claim in that regard.
You want to?
Right. I'm going to return to the pattern, and it's a kind of narrow question, David. I feel like I know you in the front row, so I'd like to be friendly. You had mentioned that the preemptions questions here would be focused on mobile sources, that those would be the sources where preemption would be might preempt essentially state-level claims or remedies. And yet you describe litigation where you're suing oil and gas companies, and I wouldn't say entirely, and one could argue about natural gas of late, but clearly the majority, I think, of oil and gas is going to mobile sources, not to mention it's a bit circular that the communities want this to fix their roads so the mobile sources can run. I mean, so that does go a little to the question of whether this is, I don't mean this demeaningly, but it's a kind of public relations or public use, the question being answered, as opposed to the question of really great damages that would actually help the communities involved.
I think your question is, does the Clean Air Act preempt, because the Clean Air Act preempts separate state tailpipe standards, how does that play into a damage claim based on fossil fuels, which are largely used in vehicles? The answer is that when Congress preempted states from setting tailpipe standards, it was because they don't want vehicle manufacturers, to have to make 50 different kinds of Chevy Impalas or 30 different kinds of Chevy Impalas. They want one kind of Chevy Impala. But states are free to decide what kind of fuels go into those cars. And as a matter of fact, as I said, California and Oregon both have a low carbon fuel standard. And the oil industry has sued over them, but has made no claim that the state has no authority to adopt these standards. There was one claim saying this particular issue in a Clean Air Act amendment did preempt part of one of the regulations, and the Ninth Circuit shot that down twice. So the answer is it's the industrial policy. We don't want manufacturers to have to make 30 different kinds of Chevy Impalas, but the Congress has said states are completely free to regulate the contents of fuels, including how much carbon dioxide they put in the air when burned.
We have time for one more question. Sir, since you're on the front, I think, Andy, you will get the last question. Thank you.
I think it's only appropriate to ask David a question.
You guys owe me lunch.
2 questions. Fresh off your remand and removal briefing, first, could you say a little bit about how, I assume it's Colorado law, how Colorado law can govern emissions from outside Colorado, or for that matter, outside the United States? And then, relatedly, can you win without imposing liability under Colorado law for non-Colorado emissions?
Oh, yeah. The conduct isn't what we're getting at. The conduct isn't the burning. That's just a piece of the causal chain. The conduct is the production and marketing and not disclosing what you knew about the product. The fact that it's burned elsewhere is just a piece of a causal chain. It's not part of the conduct that is being that we think is going to be adjudicated in these cases, and we don't need to impose liability on some guy driving a car in Bangladesh. Again, we're just seeking it from the people who didn't disclose what they knew about the bad effects of what they were selling.
Does anyone else have any final thoughts?
I would just offer people a reference if you want a good catalog of all of this stuff. The Sabin Center for Climate Change at Columbia has what I think is a pretty comprehensive listing of all the nuisance, public trust, all the climate change cases.
Well, this has been a fascinating discussion. Please join me in thanking this panel for our...
You work so hard on all these questions.
That's okay. I was glad I didn't have to ask them.
Sorry, my hands are so cold.
No, you did a great job.
Thank you.
Yeah.
My pleasure.
Yeah.
Okay. Yeah, there we go. Sure. Let me come down so I'm not like up here.
I'll just give you